Good afternoon, everyone. My name is Preet Bharara, and I'm the United States Attorney for the Southern District of New York. Before we talk about the civil rights case we are announcing today, I want to say a few words about the terrorism charges that we filed yesterday evening against Ahmad Khan Rahami. First, I'm pleased and honored to be standing here today with Bill Sweeney. There he is, the new Assistant Director in charge of the New York Field Office. There's been a lot said already about how the bombing in Chelsea occurred on the first full day of work for the new police commissioner, Jimmy O'Neill. I want to echo those who have remarked how lucky we are to have such a fine police department and a fine new police chief who is literally ready on day one to handle the challenges of keeping New York safe. But I want to note that the city also has a new FBI assistant director in charge in the form of Bill Sweeney, who only has a few weeks in this current position, who worked nonstop with the NYPD and the Joint Terrorism Task Force to investigate, capture, and now charge the alleged bomber. From the moment the bomb went off in Chelsea Saturday evening until Rahami's capture in Linden, New Jersey on Monday morning, it was just about 39 hours. And that, as many people have already said, is an amazing feat. And we should all be immensely thankful and grateful to the tireless and seamless work of the FBI, NYPD, the JTTF, the Linden Police Department, among countless other law enforcement agencies who got us to the finish line there. I also want to take the opportunity to acknowledge and thank the work of the investigators and prosecutors in my own office who have worked on this investigation around the clock. They, like many of the agents and officers at the JTTF, have barely slept since Saturday, and they're continuing to work hard on the investigation. They are Assistant U.S. Attorneys Emil Bove, Sean Crowley, Andrew DeFilippis, Nick Lewin, and their supervisors John Cronin and Sean Buckley, as well as our investigators George Corey, Charlie Villani, and Kevin Song. Thanks to their work yesterday evening, we filed a 4-count criminal complaint in the Southern District of New York against Rahami, charging him with acts of terrorism, including use of weapons of mass destruction, bombing of a place of public use, and destruction of property by explosives for the Chelsea bombing. Federal charges were also brought against him in New Jersey, as well for the bombs Rahami allegedly planted in Seaside Park and Elizabeth, New Jersey. The first case to proceed will be the federal case brought yesterday in Manhattan Federal Court. We have filed a writ for Rahami with the U.S. Marshal Service, and we expect that he will soon be brought into this district. The charges we unsealed last night lay out the considerable evidence that the FBI and NYPD was able to gather in a short period of time, and the evidence, we believe, shows that this was a premeditated act of terrorism. That evidence includes 12 fingerprints recovered from the undetonated bomb from the 27th Street location in Chelsea, including on the pressure cooker, duct tape, and the triggering cell phone. Surveillance video of Rahami allegedly near the 23rd Street bomb, 27 minutes before the explosion. Surveillance video of Rahami walking with a suitcase near 27th Street just minutes after the explosion, 4 blocks south. License plate readers showing a car tied to Rahami's residence, entering Manhattan through the Lincoln Tunnel about 2 hours before the explosion and leaving Manhattan about 2 hours after. And also a handwritten journal found on Rahami at the time of his arrest, talking about, among other things, jihad, pipe bombs, a pressure cooker bomb, and the sounds of bombs heard in the street, as well as laudatory references to Anwar al-Awlaki and Osama bin Laden. This weekend, as you all appreciate, the American way of life was attacked, and everyday routines were shaken by explosions in Chelsea and in Seaside Park. The response to these misguided acts of terror has been classically American, and what we have come to expect in our city from New Yorkers: care for the victims, calm in the midst of chaos, and swift law enforcement action. Now, thanks to that response, Rahami will face federal terrorism charges in a court of law. So now let me turn to what we came here to talk about, showing in some ways the diversity of our docket. Sometimes law enforcement does us so proud, as we saw this week. Sometimes, sadly, law enforcement does not, and that brings me to today's case. Excessive use of force in prisons, we believe, has reached crisis proportions in New York State. We have taken aggressive action, time and time again, at Rikers Island, but the prison problem, sadly, does not end there. Now we are addressing the issue, the same issue of abuse at Downstate Correctional Facility in Fishkill, New York. Today, we unseal charges against 5 former correction officers at Downstate for violating the constitutional rights of an inmate named Kevin Moore. They are being charged for a brutal beating and a brazen cover-up. 2 of those 5 have already pled guilty and are cooperating with the government. First, the beating. It took place on November 12, 2013, as the indictment sets forth. On that day, Kevin Moore was on his way to Rikers Island from another upstate facility and was to be held just overnight at Downstate. Shortly before Moore arrived at Downstate, he was told that he would be held in cells designated for inmates with mental health issues. Moore became very agitated because he did not have mental health issues himself and feared that a designation to that unit would affect his future placement in prison. We allege that in retaliation, the charged correction officers struck Moore with wooden batons, punched him repeatedly in the face and ribs, kicked him in the head and in the groin, and even ripped dreadlocks off his head, one allegedly picking up the ripped dreadlocks from the floor, saying that he wanted to save them as a trophy. Even after Moore was on the ground, not resisting, begging them to stop, the officers continued to beat him, we allege. That beating left Moore in a pool of his own blood, with 5 broken ribs, facial fractures, a collapsed lung, and severe contusions all over his body. And it landed him in the hospital for 17 days. Second, the cover-up. Almost immediately after the beating, the cover-up began. As alleged, knowing that their attack on Moore had been unjustified, the correction officers concocted a cover story and plan. So what did they do? They claimed that Moore had physically attacked a correction officer first, and the officer simply responded to the attack with just the reasonable amount of force necessary to restrain him. To support the false story, the correction officers, we allege, went to great lengths. We allege that they took a baton and struck another officer hard to make it look like it was the victim, Kevin Moore, who had inflicted the injury. That officer, by the way, is one of our cooperating witnesses. So a cruel and savage beating, followed by a shameless cover-up. That's what we allege in the charges announced today. So we announced charges against 5 defendants, former Sergeant Kathy Scott, former correction officers George Santiago Jr., Carson Morris, Donald Cusman, and Andrew Lowry. The last 2, Cosman and Lowry, have already pled guilty to civil rights violations and obstruction charges and are cooperating with the government in this case, as I mentioned. All 5 defendants are charged with federal civil rights crimes for violating Moore's constitutional rights and with 2 counts of falsifying records and obstructing justice for their allegedly fake cover-up story, which were filed in various official reports. As you, I'm sure, appreciate, federal civil rights cases against correction officers who violate inmates' constitutional rights are hard to make. They're not easy. And that's particularly the case, whereas here, officers get together and come up with a cover story. We were able to make the charges announced today thanks to the tireless work and collaboration of our law enforcement partners, so I want to thank them. First, I want to thank the FBI, represented here today by Bill Sweeney, who I mentioned. The FBI is our partner in so many different kinds of cases that I can't mention them all. In particular, I want to thank FBI Special Agents Michael Kastner and Jillian Guerrera. I also want to thank and acknowledge my friend Dutchess County District Attorney William Grady and his office, oh, there he is, and his office for the great collaboration in this case. In particular, I want to thank ADA Matthew Weishaupt and investigator Gary Lee. I want to also recognize the Department of Corrections and Community Supervision's Office of Special Investigations, represented here today by Chief Steve Mayer, for their cooperation in this investigation. And in particular, with respect to that agency, I want to thank investigators John Pratt and Tom Knight. Finally, I want to thank the investigators and career prosecutors in my office who have worked hard in making this important case. In particular, Assistant United States Attorneys Daniel Philor and Pierre Armand, as well as their supervisors, Perry Carbone, Miriam Roca, Lara Eshkenazi, David Kennedy, Tara Lamort, and our investigator, Sean Smith. As I have said on other occasions when we have brought cases like this, inmates may be walled off from the public, but they are not walled off from the Constitution. When correction officers viciously beat an inmate in their charge, when they collude among themselves to cover it up, as alleged here, they trample on the Constitution and the very laws they have sworn to uphold. With that, let me bring to the podium our new Assistant Director in charge of the FBI, Bill Sweeney.
Good afternoon. Last November, inmate Kevin Moore was brought to Downstate Correctional Facility in Fishkill, New York, in anticipation of his ultimate transfer to Rikers Island. Shortly after his arrival, Moore was asked to remove his shoelaces in preparation for confinement in a cell designed for inmates with mental health issues. Fearing his placement in the cell would set a precedent for his future mental health status in the system, he questioned the officers on his decision. What followed was nothing short of sheer deprivation of liberty without due process of law. As alleged, the defendants were relentless in their approach to admonish Moore for speaking up, brutally beating him with their boots and batons. In a symbol of their immorality, one of the officers allegedly boasted of the group's illicit conduct by referring to the dreadlocks ripped from Moore's scalp as souvenirs. In sum and substance, it's alleged that the officers charged today exerted unnecessary force and later denied their prisoner medical treatment afforded to him under the law. They concocted a cover story to disguise their heinous actions, filed false reports, and even went so far as to cause the appearance of fake injuries in support of their lie. This type of behavior is outrageous. It will not be tolerated within our criminal justice system, and those who subject others to cruel, unusual, and unnecessary punishment will be swiftly removed from serving in any official capacity. Many thanks, as always, to our partners in this and so many other investigations, especially U.S. Attorney Preet Bharara, Perry Carbone, who I know well and mispronounced his name, Miriam Roca, co-chiefs of the White Plains U.S. Attorney's Office for the Southern District, Assistant U.S. Attorneys Dan Filor and Pierre Armand, the New York City Department of Corrections and Community Supervision, the Office of the Dutchess County District Attorney, and the FBI's Hudson Valley White Collar Crime Task Force, including the Orange County Sheriff's Office and the offices of the Orange and Sullivan County District Attorneys. I'd also like to thank and congratulate the investigative team. I extend my sincere congratulations to investigators John Pratt and Tom Knight from the Department of Corrections and Community Supervision, Sean Smythe, criminal investigator from the Southern District, and FBI Special Agents Michael Kastner, Jillian Guerrera, and Supervisory Special Agent Eugene Hagan for their hard work on this important investigation. Thank you.
Thanks very much. Now let's hear from our District Attorney in Dutchess County, Bill Grady.
Good afternoon, and thank you, Preet. I'd like to first compliment Mr. Bharara and his staff on the unconditional commitment and dedication that he and his office have shown developing what was, for us at the Dutchess County level, a very difficult and challenging case. The grand jury indictment and existing pleas in this case would not have happened were it not for the close cooperation and partnership between our offices. I'd also like to express my appreciation to the FBI and the Office of Special Investigations from the Department of Corrections in helping us to all achieve a successful outcome in this case. As you know, many of you, Dutchess County is unique somewhat in that we have three major penal institutions in our county employing several thousand correction officers, who I might add the overwhelming majority of whom do an outstanding job. Unfortunately, when incidents like this happen, the message has to be very clear and unequivocal, which I think it is, and that is that we will pursue all means necessary to ensure that those offenders responsible for egregious conduct such as this will be held fully accountable. Early on, when this case first started, there was some mention of it in the paper with regard to the fact that it may very well have been pending in our grand jury as a part of an investigation, and it just died there. Well, that was not the case, so I think that I would like to shortly and briefly overview for you a brief chronology of events so you can better appreciate where we fit in this particular case and how we got to this, conference today. My office first became involved in the case in January of 1914 when the Office of Inspector General initiated an outreach to our office and requested that we look into what was described to us as an egregious incident that occurred at the Downstate Correctional Facility in November of 2013, in that an inmate had been seriously injured after an altercation with a number of correction officers. During the next several months, my office spoke with numerous potential witnesses in this case in an effort to develop enough evidence to present to a Dutchess County grand jury. However, it became readily apparent that some key witnesses would not cooperate unless subpoenaed and forced to testify before the grand jury. At this point, we faced a dilemma that every other prosecutor in the state of New York faces in cases like this, and that is currently under New York state law, anyone who is forced to testify in such a manner automatically receives what is called transactional immunity. In other words, if a witness is forced to testify under a subpoena, and it turns out that that person was the one who in fact was criminally responsible for the conduct, immunity would attach and he would not be prosecuted for that crime. Obviously, such an option was not acceptable to us at that time, and we then began discussions with Mr. Browder's office regarding the investigative alternatives that would be available that would enable us, both of us, to lead a full and complete investigation in this case. I would like to, at this point, sincerely thank Mr. Browder and his willingness to take the lead in this investigation. Our federal partners would not be limited in the same way as we were, and we were able to use the federal grand jury to compel the testimony of key witnesses without the fear of creating a transactional immunity issue. They were also able to obtain the cooperation and guilty pleas of 2 participants in this beating, as we have heard. Since our agreement to conduct the investigation jointly, we have continuously worked with the United States Attorney to develop that investigation to the point that it's at today. And we will continue to work jointly with Mr. Browder's office during the pendency of this case. And as other speakers have done before me, I would like to especially commend Bureau Chief Matt Weissop of my office, who was involved in this case from the very beginning, Assistant U.S. Attorneys Dan Filor and Pierre Armand, the United States investigator Sean Smith, and FBI investigators Jillian Guerrera and Mike Kasner for their dedication and hard work in bringing this investigation to a successful conclusion. Thank you very much.
Thanks, Bill. Happy to take your questions about the civil rights case.
John Barry. What was Mr. the victim, what was he in for? What was the crime that he had committed?
I'm not going to comment. That's not relevant to whether or not his constitutional rights were deprived, and it's not a part of the indictment, so I'm not going to comment on that. Yep.
There's a number of similar cases around the state involving these inmates and citizens, including the road Fishkill, where an inmate died last year, which I think your office is looking into. Can you give any update on that case, or whether, can you talk about whether it's possible giving your office jurisdiction to open a broader case that might encompass more of the state citizens, perhaps the whole state citizens?
Yeah, with respect to your first question on whether we're looking at the incident that occurred at Fishkill, I'll confirm again that we are. We made that announcement. These things take time to investigate thoroughly and make sure that we have a case. It's not always possible to bring a case, so we're still looking at that. With respect to your second question, there are ways in which one can take a broader look. It would not be crazy for folks to suggest that there may be something more endemic to prisons around the state and, in fact, around the country, but I'm not going to comment any further than that. Yeah.
Chief, the case of Fishkill you referred to, you Samuel Howell.
Yes.
I just wrote a story about an inmate, Benjamin Van Zandt. He committed suicide in Fishkill after he witnessed the beat-up squad there in action. And the beat-up squad, if you recall, also is alleged to have killed Samuel Howell. These cases, these 2 cases that I just mentioned, and this case that we're talking about today, all are related somehow to mental health issues, prisoners with mental health issues. In this case, you said that, as alleged in the indictment, the corrections officer sought to place the victim in a mental health unit. I'm wondering if there is any particular focus on how mentally ill prisoners are treated in your investigation as a result of your investigation into Harrow in this case.
That's a complicated question, how you deal with mental health in prisons. As I mentioned at the start of my remarks, in addition to bringing particular criminal cases against particular correction officers who we think have used violence excessively against inmates and violated their constitutional rights. In addition to that, we've also litigated successfully against the city with respect to Rikers Island, dealing with lots of issues that touch upon that, although that's not been the prime focus of our civil suit against the Department of Corrections in the city. I think that, speaking more broadly, and separately from how we're prosecuting individual criminal cases, where the issue of mental health is not necessarily relevant, although it can be, depending on and what the use of force was, and if it was commensurate with the behavior of the inmate. I think that as a reasonable person and a person who lives in the state and reads the newspaper, and whose people investigate these kinds of cases, that it is a big problem that you have maybe not enough training on how to deal with mental health issues in prison. Our report with respect to Rikers Island noted, I forgot what the exact percentage was, but a very substantial percentage of the population there that has to be treated in a particular way, could be characterized as having mental health issues. So I think it's a complicated policy issue. It enters into the debate with respect to particular charges against corrections officers in a roundabout way, but it's something everyone needs to be sensitive to. And more importantly, I think it's for institutions that are running prisons to be sensitive to that and figure out the best way to deal with that problem.
Adam Pascal from Courthouse News. Every Kevin Moore in the New York prison database is wrong. Would you be able to confirm that Kevin Moore, would you be able to, A, confirm his race? Does your office believe the attack was racially motivated? And what was the race of the officers who attacked?
There's no allegation of racial animus. We have not charged a hate crime here. We don't believe there's evidence of racial animus, so it's not charged, so I'm not going to comment on the race. And if you know the race of everyone named Kevin Moore, then you've answered your own syllogism, I think. Yeah.
It seems odd that charges in the Lahana case were brought in here in Manhattan and the district in New Jersey. Is there competition over where this case is going to be brought? And can you tell us when you expect him to be brought to the district?
Yeah. As I said, when we were standing with the head of the FBI and the police commissioner a couple of days ago, the race was to get and capture the suspect who had planted the bomb in Chelsea and in a couple of spots in New Jersey. That's what everyone races to do all the time. With respect to where charges are brought, I think the feeling of the department was that with respect to bombs planted and that went off in 2 different states and 2 different jurisdictions, that the potential defendant should be held accountable for all his conduct. Now, obviously, you can't do things simultaneously, even though cases might be filed simultaneously. The decision was also made based on the fact that I think New York is always a prime target for terrorism currently and will be for the foreseeable future, and that the massive harm was done in New York. I think 31 people went to the hospital based on the bomb that went off on 23rd Street, that this is the appropriate and right place for the case to proceed initially. And then depending on how that turns out, other jurisdictions may pursue their cases as well, or there could be an overall resolution of the case. But the feeling was that you want to hold someone accountable for everything that he may have done that's alleged in various charging documents. But the right way for it to go is for it to happen here first.
And when do you expect him here?
Yeah. So we don't know that answer yet. Right now, he is in local custody in New Jersey. We have filed, as I mentioned, what's called a writ with the United States Marshal Service, which gets them to go and bring him to our jurisdiction. Now, the timing is dependent on a lot of things, operational issues, what's going on at the jail. In this case, more specifically, perhaps relating to his medical condition. So we don't know the precise timing. We expect it won't be very long, but I can't tell you the precise timing.
You may have seen David Patton of the federal defenders filed a letter with Magistrate Goranson expressing some urgency, saying he's been questioned by federal agents without a lawyer, and expressed some urgency, was willing to even do a video conference over there. You now said there's a writ with the marshals. What is your position on the proposal that he be presented immediately, either there or by video, instead of waiting?
As a legal matter, it's our understanding that the defendant is in custody of the local authority. He is not in federal custody. He has not been arrested by federal authorities. And in the ordinary case, that doesn't happen until the person is transported to our jurisdiction. So our folks will be in discussion, I think have been in discussion with David Patton, who's an excellent lawyer and cares deeply about fair trials, as do we, and we'll work that out with him. But at the moment, he is not under federal arrest. Yeah.
Describes an incident
Yeah, every detail that we were comfortable relating about that cell phone is in the complaint, and it's a short complaint, and it sounds like you've read it, so I'm not going to go beyond what's in there. There's, as you described very well, John, there's a videotape showing what appears to be someone's backyard with a pipe in the ground and an explosion that takes place, and I think it's described very well in the complaint. Yeah. I'm not going to talk about anything with respect to any other person other than the defendant who was arrested and who was charged. Although I will note, as others have noted, that the investigation continues to make sure that we figured out everything possibly that we can with respect to the event. Yeah.
Can you talk a little bit about the ease as to how he got this material over eBay and the internet according to the complaint? Is there a concern that you can still buy all these materials almost in one way, but in environment both? You can kill people and harm people. The ease of it, your concern.
Yeah, I think a lot of people spend a lot of time thinking about how to regulate certain things you can get in stores or certain things you can get on the internet. There's a problem with fertilizer, which was, the base of the bomb, I believe, in the Faisal Shahzad case from 6 years ago. But it becomes difficult, I think, and Bill should chime in if he wants. It becomes difficult to figure out when people are buying, things that are not illicit in and of themselves. For example, if someone buys masking tape in connection with a bank robbery and then separately buys a mask and then separately buys something else that helps to facilitate the crime, it becomes a little bit difficult to say you can't buy those things. And in this case, as is outlined in the complaint, he bought a number of things basically in his own name over eBay, including ball bearings and other items. I think we have gotten a lot better at making sure there are tripwires when people are buying things that might be suspect. So it's a concern people have, but there are limitations to that when people are buying things that are not inherently unlawful or explosive. Yeah.
Back to the Fishkill case, the residences were not listed for the two individuals who pled guilty. Do we have those residences? And do we know if any of the 5 are former Dutchess County residents or present?
I don't know if we put that out in the release. You can call the press office after and ask that question.
When they do send like a story on form, vacations are so far that he's a lone actor. I was wondering if that's still the case. This was the FBI representative who called just a moment ago, held up some of the notes, transcripts of the notes, saying that Mr. Rouhani was receiving inspiration from the ISIS spokesman, and that this may have been an ISIS-inspired attack on top of his previous what we know about the Al-Qaeda bombings and some other. Can you address what the representative has said and the lone actor?
I'm not going to address what the representative said as far as whether he's a lone actor. That's still the path that we're following, but we're keeping all the options open, like I mentioned 2 days ago, as we develop that entire network to figure out who knew what and when and where. But right now, we're focused on him.
What did Rouhani's wife say?
I'm sorry?
What did Rouhani's wife say?
I'm not going to comment on what anybody said about the case at all.
Your response, you mentioned earlier about the classic American response to the Rouhani case. What's your response to people like Senator Lindsey Graham, who opined in the wake of this that the United States should go that road and declare him a U.S. declare he's a U.S. citizen and an enemy combatant?
It's not my inclination to comment on what a politician is saying in an election year with respect to a criminal case. But I'll say what I've said before, which is to stand by the track record of this office. And decisions about a forum in which someone is going to be tried who's been accused of acts of terrorism, whether that's going to be in an Article III court or that's going to be in a military commission. We had a case once upon a time that was supposed to come here, and people way above my pay grade, and there are such people, decided it should go elsewhere. And those are debates for people who are responsible for policy and politics that they decide. The only thing I will say is what law currently allows and dictates is that you handle the kind of conduct that occurred here in precisely the way that we're handling it, both we and the District of New Jersey and the Department of Justice as a whole. And we have a good track record of getting it done properly and holding people to account over the course of a number of years. And I stand by that track record, and I think the American people should be proud of the work that the men and women of this office in conjunction with the JTTF have done with respect to prosecuting and holding accountable terrorists. Thanks.
That was the last question.